The H1B Guy here, and today, the H1B Guy news for the week ending June 7th, 2024. Today I'll cover another H1B discrimination lawsuit and additional H1B and L1 biometric fees proposed on the Federal Register. But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube and like this video so that I can continue to produce more content like this for you. I also wanted to mention that H1B Guy offers a variety of consulting services. I help businesses and individuals solve complex work authorization issues in the recruitment process while bringing awareness to employment-based immigration benefits. If I can help you, please reach out. I'd love to hear how. And you can book an appointment directly with me via the h1bguy.com. Today's news is brought to you by Syndesis, the ideal plan B for high-skilled immigrants currently located in the U.S. whose status may be uncertain. By PERM-Ads.com, the industry leader in providing a seamless experience for employers and immigration attorneys navigating the complex PERM recruitment ad phase of the labor certification process. And by Mob Squad. Are you a technology professional facing U.S. work visa-related challenges? Don't leave your fate up to chance. Our partner Mob Squad has a solution. Join the squad. Now, the news. On June 4th, 2024, Andrew Krybaum, in a post for Bloomberg Law titled JPMorgan Retaliated Against Indian H-1B Worker Lawsuit says, quote, JPMorgan Chase and Company unlawfully fired an Indian software developer on H-1B visa after he complained about race and national origin discrimination, according to a new lawsuit. Praful Kahar alleged that executives at the bank gave him work assignments that did not match up with the job duties outlined in the application for his specialty occupation visa sponsored by the company. Those executives also put him under a microscope, were constantly searching for flaws, and had misrepresented Kahar's work performance, he said in a complaint filed Monday in the U.S. District Court for Eastern District of Texas. After Kahar complained about what he viewed as discrimination, JPMorgan retaliated by firing him in violation of Title VII of the 1964 Civil Rights Act, Section 1981 of the 1866 Civil Rights Act, the lawsuit said. Kahar was employed as vice president of product management at Chase's offices in Plano, Texas, where he worked on cloud networking beginning in January of 2023, according to the lawsuit. But executives at the bank assigned him tasks with unrealistic and unobtainable completion dates, misrepresented the work that he had performed, misquoted statements regarding his work, and falsely asserted that his suggestions and proposals were not technically feasible, the lawsuit said. Executives retaliated against Kahar by assigning further work projects outside the scope of his job description after he complained about discrimination, the complaint said. He was terminated in April during his probationary period at the company. The lawsuit seeks back pay and compensatory damages. Kahar is represented by Rod Tanner of Tanner and Associates PC. I've covered numerous H-1B lawsuits over the last 4 years here on this platform. This lawsuit is yet another one that will join the list of former employees filing a discrimination suit against their former employer while on H-1B visa. With this one being filed specifically against JPMorgan Chase, who has an annual revenue of 2023 of $148 billion, which finds itself in a very peculiar legal battle that is seeking pay for not only lost wages, but additional compensation for damages. The lawsuit has a laundry list of fraudulent and discriminatory activities, or as I like to say, where there's smoke, there's fire. I'm not insinuating guilt, but merely stating that the list of accusations is serious and significant. JPMorgan Chase at one point in 2022 employed over 3,000 H-1B visa employees, but has seen a significant decrease in that number to just above 600 for 2023. They also hold a 92+% approval rate on their H-1B applications. I'll continue to monitor this lawsuit, but I really expect there will be some kind of settlement on behalf of both parties. On June 6, 2024, in a post on the National Law Review from Barry Appelman and Leiden, titled United States DHS proposes regulation expanding application of 911 response and biometric entry exit fee for H1B and L1 visas. Quote, the Department of Homeland Security published a proposed regulation today to amend and clarify regulations on the 911 response and biometric entry exit fee for H1B and L1 visas. The 911 biometric fee only applies to petitioning employers with 50 or more employees, with more than 50% of the employees in the U.S. in H1B or L1 non-immigrant status. The proposed regulatory changes would codify the agency's interpretation of ambiguous statutory language to require covered employees submit the 911 biometric fee for all extension of stay petitions, including those that do not involve a change of employer. The 911 biometric fee will be submitted for these petitions regardless of whether a fraud fee applies. The 911 biometric fee would continue to apply unchanged to petitions seeking an initial grant of status or change of employer. DHS states in the proposed regulation that these changes will help DHS comply with its congressional mandate to implement a biometric entry exit data system. Any changes to fee requirements for covered employers would not take effect until DHS considers the comments it receives and issues a final regulation. Again, this fee only applies to companies with 50 or more employees with more than 50% in the U.S. and H1B or L1 status. Currently, on top of other filing fees, covered employees pay $4,000 extra for each H1B petition and $4,500 extra for each L1 initial petitions and change of employer petitions, but not extensions of stay with the same employer. So this notice for proposed rulemaking comes with 30 days comment period that will end on July 8th, 2024. However, I don't see where there will be a significant enough number of comments speaking out against adding the additional biometric fee to both H1 and L1 A and B visas. This is clearly a continued effort on behalf of DHS, USCIS, and maybe even the DOL to a certain extent to continue to increase fees for employers who are above what we call the 50-50 rule, meaning over 50% of their employee workforce here in the US are on H1B visa or L1 visa. Utilizing this opportunity to expand the fees associated with biometrics for H1B dependent employers will easily add an additional revenue stream for USCIS, which is, of course, self-funded based on their long list of filing fees. The reality is that this fixes a lost opportunity cost for USCIS while increasing the cost to employ H1B or L1 visa holders for dependent organizations, which, in my estimation, will receive very little resistance from the vast majority. For the full post on the H1B Guy news for the week ending June 7th, 2024, please check out the H1BGuy.com. And a reminder that today's news is brought to you by Syndesis, the ideal plan B for high-skilled immigrants currently located in the U.S. whose status may be uncertain. If you're facing an H-1B denial or OPT expiration, don't get caught off guard. Make sure you have a plan B, and Syndesis is your answer. They'll gladly help you navigate the process, and if you'd like to find out if you qualify, please be sure to use the link in the video description below, and someone from Syndesis will be in touch. By PERM-Ads.com, the industry leader in providing a seamless experience for employers and immigration attorneys navigating the complex PERM recruitment ad phase of the labor certification process. If you're looking to reduce your cost and overhead associated with PERM labor certification recruitment advertising, let PERM-Ads.com help you. And by Mob Squad. Are you a technology professional facing U.S. work visa-related challenges? Don't leave your fate up to chance. Our partner Mob Squad has a solution. Mob Squad helps technology professionals facing U.S. work visa-related uncertainty remain working with their current U.S. employer nearshore from Canada, as well as technology professionals from around the world who are seeking to find a rewarding opportunity in North America. Through their partnership with the Canadian government, they can obtain a Canadian work permit for you and your spouse in as little as 4 to 6 weeks. So, whether you're looking to stay working with your current U.S. employer or you want to find a new opportunity in Canada, please find out how the team at Mob Squad can help you via the link in the video description below. Join the squad. Just wanted to ask you again to please like this video, subscribe to the H1B Guy channel here on YouTube, and click the bell for notifications so that you're notified anytime we post new content here to this channel. If you've made it this far, I just want to say thank you for taking the time to watch my video. Really appreciate your support. The H1B Guy, your global source for all things H1B.